Law is a system of rules that are enforced through social institutions to govern behavior. Laws can be made by collective legislature or by a single legislator, resulting in statutes by the executive through decrees and regulations, or by judges through binding precedent, normally in common law jurisdictions. Private individuals can create legally binding contracts, including arbitration agreements that may elect to accept alternative arbitration to the normal court process. The formation of laws themselves may be influenced by constitution, written or tacit, and the rights encoded therein. The law shapes politics, economics, history and society in various ways and serves as a mediator of relations between people. A general distinction can be made between civil law jurisdictions, in which the legislature or other central body codifies and consolidates the laws, and common law systems, where a judge-made precedent is accepted as binding law. Historically, religious laws played a significant role even in settling of secular matters, which is still the case in some religious communities, particularly Jewish, and some countries, particularly Islamic. Islamic Sharia law is the world's most widely used religious law. The adjudication of the law is generally divided into two main areas referred to as criminal law and civil law. Criminal law deals with conduct that is considered harmful to social order and in which the guilty party may be imprisoned or fined. Civil law deals with the resolution of lawsuits between individuals or organizations. Law provides a rich source of scholarly inquiry into legal history, philosophy, economic analysis and sociology. Law also raises important and complex issues concerning equality, fairness, and justice. There is an old saying that all are equal before the law, although Jonathan Swift argued that laws are like cobwebs, which may catch small flies, but let wasps and hornets break through. In 1894, the author Anatole France said sarcastically, in its majestic equality, "The law forbids rich and poor alike to sleep under bridges, beg in the streets, and steal loaves of bread." Writing in 350 BC, the Greek philosopher Aristotle declared, "The rule of law is better than the rule of any individual." Mikhail Bakunin said, "All law has for its object to confirm and exalt into a system the exploitation of the workers by a ruling class." Cicero said, "More law, less justice." Marxist doctrine asserts that law will not be required once the state has withered away. Regardless of one's view of the law, it remains today a completely central institution. Definition. Mainstream definitions. Numerous definitions of law have been put forward over the centuries. The Third New International Dictionary from Merriam-Webster defines law as, "Law is a binding custom or practice of a community, a rule or mode of conduct or action that is prescribed or formally recognized as binding by a supreme controlling authority or is made obligatory by a sanction made, recognized, or enforced by the controlling authority." The Dictionary of the History of Ideas, published by Scribner's in 1973, defined the concept of law accordingly as, "A legal system is the most explicit, institutionalized, and complex mode of regulating human conduct. At the same time it plays only one part in the congeries of rules which influence behavior. For social and moral rules of a less institutionalized kind are also of great importance. Whether it is possible or desirable to define law, there have been several attempts to produce a universally acceptable definition of law. In 1972, one source indicated that no such definition could be produced. McCobrey and White said that the question, "What is law?" has no simple answer. Glanville Williams said that the meaning of the word law depends on the context in which the word is used. He said that, for example, early customary law and municipal law were contexts where the word law had two different and irreconcilable meanings. Thurman Arnold said that it is obvious that it is impossible to define the word law, and that it is also equally obvious that the struggle to define that word should not ever be abandoned. It is possible to take the view that there is no need to define the word law. History. The history of law links closely to the development of civilization. Ancient Egyptian law, dating as far back as 3000 BC, contained a civil code that was probably broken into 12 books. It was based on the concept of art characterized by tradition, rhetorical speech, social equality and impartiality. By the 22nd century BC, the ancient Sumerian ruler Ur-Nammu had formulated the first law code, which consisted of casuistic statements. Around 1760 BC, King Hammurabi further developed Babylonian law by codifying and inscribing it in stone. Hammurabi placed several copies of his law code throughout the kingdom of Babylon as stelae for the entire public to see. This became known as the Codex Hammurabi. The most intact copy of these stelae was discovered in the 19th century by British Assyriologists, and has since been fully transliterated and translated into various languages, including English, Italian, German, and French. The Old Testament dates back to 1280 BC and takes the form of moral imperatives as recommendations for a good society. The small Greek city-state, ancient Athens, from about the 8th century BC, was the first society to be based on broad inclusion of its citizenry, excluding women and the slave class. However, Athens had no legal science, a single word for law, relying instead on the three-way distinction between divine law, human decree and custom. Yet ancient Greek law contained major constitutional innovations in the development of democracy. Roman law was heavily influenced by Greek philosophy, but its detailed rules were developed by professional jurists and were highly sophisticated. Over the centuries between the rise and decline of the Roman Empire, law was adapted to cope with the changing social situations and underwent major codification under Theodosius II and Justinian I. Although codes were replaced by custom and case law during the Dark Ages, Roman law was rediscovered around the 11th century when medieval legal scholars began to research Roman codes and adapt their concepts. Latin legal maxims were compiled for guidance. In medieval England, royal courts developed a body of precedent which later became the common law. A Europe-wide law merchant was formed so that merchants could trade with common standards of practice rather than with the many splintered facets of local laws. The law merchant, a precursor to modern commercial law, emphasized the freedom to contract and alienability of property. As nationalism grew in the 18th and 19th centuries, the law merchant was incorporated into countries' local law under new civil codes. The Napoleonic and German codes became the most influential, in contrast to English common law, which consists of enormous tomes of case law. Codes in small books are easy to export and easy for judges to apply. However, today there are signs that civil and common law are converging. EU law is codified in treaties, but develops through the precedent laid down by the European Court of Justice. Ancient India and China represent distinct traditions of law, and have historically had independent schools of legal theory and practice. The Arthashastra, probably compiled around 100 AD, and the Manusmriti were foundational constitutional treatises in India, and comprise texts considered authoritative legal guidance. Manu's central philosophy was tolerance and pluralism, and was cited across Southeast Asia. This Hindu tradition, along with Islamic law, was supplanted by the common law when India became part of the British Empire. Malaysia, Brunei, Singapore and Hong Kong also adopted the common law. The Eastern Asia legal tradition reflects a unique blend of secular and religious influences. Japan was the first country to begin modernizing its legal system along Western lines, by importing bits of the French, but mostly the German civil code. This partly reflected Germany's status as a rising power in the late 19th century. Similarly, traditional Chinese law gave way to westernization towards the final years of the Qing dynasty in the form of 6 private law codes based mainly on the Japanese model of German law. Today, Taiwanese law retains the closest affinity to the codifications from that period, because of the split between Chiang Kai-shek's nationalists, who fled there, and Mao Zedong's communists who won control of the mainland in 1949. The current legal infrastructure in the People's Republic of China was heavily influenced by Soviet socialist law, which essentially inflates administrative law at the expense of private law rights. Due to rapid industrialization, today China is undergoing a process of reform, at least in terms of economic, if not social and political, rights. A new contract code in 1999 represented a move away from administrative domination. Furthermore, after negotiations lasting 15 years, in 2001 China joined the World Trade Organization. Legal theory. Philosophy. The philosophy of law is commonly known as jurisprudence. Normative jurisprudence is essentially political philosophy, and asks, what should law be? While analytic jurisprudence asks, what is law? John Austin's utilitarian answer was that law is commands backed by a threat of sanctions from a sovereign, to whom people have a habit of obedience. Natural lawyers on the other side, such as Jean-Jacques Rousseau, argue that law reflects essentially moral and unchangeable laws of nature. The concept of natural law emerged in ancient Greek philosophy concurrently and in entanglement with the notion of justice, and re-entered the mainstream of Western culture through the writings of Thomas Aquinas, notably his treatise on law. Hugo Grotius, the founder of a purely rationalistic system of natural law, argued that law arises from both a social impulse, as Aristotle had indicated, and reason. Immanuel Kant believed a moral imperative requires laws be chosen as though they should hold as universal laws of nature. Jeremy Bentham and his student Austin, following David Hume, believed that this conflated the bullshit and what ought to be a problem. Bentham and Austin argued for law's positivism, that real law is entirely separate from morality. Kant was also criticized by Friedrich Nietzsche, who rejected the principle of equality, and believed that law emanates from the will to power, and cannot be labeled as moral or immoral. In 1934, the Austrian philosopher Hans Kelsen continued the positivist tradition in his book The Pure Theory of Law. Kelsen believed that although law is separate from morality, it is endowed with normativity, meaning we ought to obey it. While laws are positive bullshit statements, law tells us what we should do. Thus, each legal system can be hypothesized to have a basic norm instructing us to obey. Kelsen's major opponent, Carl Schmitt, rejected both positivism and the idea of the rule of law because he did not accept the primacy of abstract normative principles over concrete political positions and decisions. Therefore, Schmitt advocated a jurisprudence of the exception, which denied that legal norms could encompass all of political experience. Later in the 20th century, H.L.A. Hart attacked Austin for his simplification limitations, and Kelsen for his fictions in The Concept of Law. Hart argued law is a system of rules, divided into primary and secondary ones. Secondary rules are further divided into rules of adjudication, rules of change, and the rule of recognition. Two of Hart's students continued the debate. In his book Law's Empire, Ronald Dworkin attacked Hart and the positivists for the refusal to treat law as a moral issue. Dworkin argues that law is an interpretive concept that requires judges to find the best fitting and most just solution to a legal dispute, given their constitutional traditions. Joseph Raz, on the other hand, defended the positivist outlook and criticized Hart's soft social thesis approach in The Authority of Law. Raz argues that law is authority identifiable purely through social sources and without reference to moral reasoning. In his view, any categorization of rules beyond the role as authoritative instruments in mediation are best left to sociology, rather than jurisprudence, positive law and non-positive law discussions. One definition is that law is a system of rules and guidelines which are enforced through social institutions to govern behavior. In The Concept of Law, Hart argued law is a system of rules. Austin said law was the command of a sovereign, backed by the threat of a sanction. Dworkin describes law as an interpretive concept to achieve justice in his text titled Law's Empire, and Raz argues law is an authority to mediate people's interests. Holmes said, "The prophecies of what the courts will do in fact, and nothing more pretentious, are what I mean by the law." Quote, in his treatise on law, Aquinas argues that law is a rational ordering of things which concern the common good that is promulgated by whoever is charged with the care of the community. This definition has both positivist and naturalist elements. Economic analysis in the 18th century, Adam Smith presented a philosophical foundation for explaining the relationship between law and economics. The discipline arose partly out of a critique of trade unions and U.S. antitrust law. The most influential proponents, such as Richard Posner and Oliver Williamson, and the so-called Chicago School of Economists and lawyers including Milton Friedman and Gary Becker, are generally advocates of deregulation and privatization, and are hostile to state regulation of what they see as restrictions on the operation of free markets. The most prominent economic analyst of law is 1991 Nobel Prize winner Ronald Coase, whose first major article, The Nature of the Firm, argued that the reason for the existence of firms is the existence of transaction costs. Rational individuals trade through bilateral contracts on open markets until the costs of transactions mean that using corporations to produce things is more cost-effective. His second major article, The Problem of Social Cost, argued that if we lived in a world without transaction costs, people would bargain with one another to create the same allocation of resources, regardless of the way a court might rule in property disputes. Coase used the example of a nuisance case named Sturgis v. Bridgman, where a noisy sweetmaker and a quiet doctor were neighbors and went to court to see who should have to move. Coase said that regardless of whether the judge ruled that the sweetmaker had to stop using his machinery, or that the doctor had to put up with it, they could strike a mutually beneficial bargain about who moves that reaches the same outcome of resource distribution. Only the existence of transaction costs may prevent this, so the law ought to preempt what would happen, and be guided by the most efficient solution. The idea is that law and regulation are not as important or effective at helping people as lawyers and government planners believe. Coase and others like like him wanted a change of approach, to put the burden of proof for positive effects on a government that was intervening in the market, by analyzing the costs of action. Sociology of law is a diverse field of study that examines the interaction of law with society and overlaps with jurisprudence, philosophy of law, social theory and more specialized subjects such as criminology, the institutions of social construction, social norms, dispute processing and legal culture are key areas for inquiry in this knowledge field. Sociology of law is sometimes seen as a subdiscipline of sociology, but its ties to the academic discipline of law are equally strong, and it is best seen as a transdisciplinary and multidisciplinary study focused on the theorization and empirical study of legal practices and experiences as social phenomena. In the United States, the field is usually called law and society studies. In Europe, it is more often referred to as socio-legal studies. At first, jurists and legal philosophers were suspicious of sociology of law. Kelsen attacked one of its founders, Eugene Ehrlich, who sought to make clear the differences and connections between positive law, which lawyers learn and apply, and other forms of law, or social norms that regulate everyday life, generally preventing conflicts from reaching barristers and courts. Contemporary research in sociology of law is much concerned with the way that law is developing outside discrete state jurisdictions, being produced through social interaction in many different kinds of social arenas, and acquiring a diversity of sources of authority in communal networks existing sometimes within nation-states but increasingly also transnationally. Around 1900, Max Weber defined his scientific approach to law, identifying the legal rational form as a type of domination, not attributable to personal authority but to the authority of abstract norms. Formal legal rationality was his term for the key characteristic of the kind of coherent and calculable law that was a precondition for modern political developments and the modern bureaucratic state. Weber saw this law as having developed in parallel with the growth of capitalism. Another leading sociologist, Emil Durkheim, wrote in his classic work The Division of Labor in Society that as society becomes more complex, the body of civil law concerned primarily with restitution and compensation grows at the expense of criminal laws and penal sanctions. Other notable early legal sociologists included Hugo Sinzimmer, Theodore Geiger, George Gervich and Leon Petrositsky in Europe, and William Graham Summer in the U.S.